Hi, here's a quick primer on criminal procedure. These are the steps that have to happen in a trial. Remember, first thing that has to happen if someone's accused of a crime is they're going to be charged with that crime. There's going to be police work to document whatever evidence is used to make that accusation. There will be a warrant for their arrest, and there was, in most cases, also going to be a warrant for the search of their home. If it's a question of probable cause, then they would not get a warrant for the search, but they would still have to get a warrant for the arrest. Unless the police officer sees somebody doing something and catches them in the act. So it starts with step one, arrest and booking. That's where the person is taken downtown and they're fingerprinted, their mugshots are taken, they're told what their Miranda rights are, and they're told what they're being charged with. Then there's a formal statement put out by the police department with the quote-unquote information. In other words, the evidence that is going to be used in brief that outline why this person is being charged with this crime. So-and-so saw something, or so-and-so, we have this fingerprint, we have this DNA evidence, we have this witness that linked this person to this crime. Third step is the arraignment. That's where an individual is given the opportunity to ask for a lawyer if they want one. If they do want a lawyer, one is appointed to them by the state and paid for by the state if the person doesn't have enough money to pay for it. From there, one of two things happen. Most cases end with a plea bargain agreement. If someone is able to avoid trial, and in exchange for avoiding trial, they get a lighter sentence. They often will do that. That saves the government time and money because they get to spend less time on trials, and it makes it better in some cases for people who are accused of a crime if they are willing to admit that they did something, because they'll get a lower amount of prison time or a lower fine. So at that point you go either to a guilty plea where the person admits their wrongdoing, or to a jury trial. There are 12 members of the jury, and in the jury trial evidence is going to be presented. That's the place where the prosecution has to convince the jury that someone is guilty beyond a reasonable doubt. If there's any reasonable doubt the person did it, then the juror should not come back with a guilty with a guilty verdict. So if they are guilty beyond a reasonable doubt, that's all 12, a unanimous jury, all 12 jurors find the person did it, then it moves to the sentencing phase. If the person is found not guilty, that means they're acquitted, they go free, and that's it. After the guilty verdict comes in, if it is a guilty verdict, you go to the sentencing phase. The judge sets the sentence, although the Congress has set what are called sentencing guidelines, or recommendations of what prison sentence lengths should correspond to what types of crimes. There's also a law called the Three Strikes Law in many states, which means that if it's your third violation, even if it's a nonviolent offense or a minor violation, the third violation is like the straw that breaks the camel's back, and you're going to go away for a long time if you're guilty of a third violation. Prison would come next. The person would serve their prison sentence unless they're sentenced to community service or probation or some other non-prison sentence. Once someone has been found guilty and has been sentenced, the next step would be to do an appeal. That's where you ask the higher court to consider the case again, to check whether there were mistakes made in the law, whether your lawyers made a mistake, whether the law was poorly applied, whether certain bits of evidence that should have been in were not in, whether certain evidence that the prosecution used to convict somebody maybe should have been excluded because of a Fourth Amendment violation. If the Court of Appeals decides that there were not mistakes made, then the conviction is upheld and the sentence remains intact. The person finishes their prison sentence. If the Court of Appeals feels that there was a mistake made, then the conviction is overturned. That means the person is released and then goes free. If the court feels that there may have been some things that the lower court should have done that they didn't think about, it can also remand the case, which means send it back down to the lower court for another trial. That's what it means when we say somebody gets a new trial. So that's criminal procedure in a nutshell. If you have questions, do further research, talk to me in class, use the PowerPoint that is attached to the website. Thanks. Bye.